So, welcome to part 10 of Business Law 1 Contracts, and we are talking about electronic agreements. We were talking about acceptances specifically. We should note that acceptances here are the same as in any other context, non-electronic agreement context. You still have to indicate voluntary assent to the terms. With click-on agreements, which we talked about briefly, that's basically just a button that says I agree to whatever the terms are, right? Other types of and they would often, when you get terms of use, and then at the bottom it says I agree, that's basically a click-on agreement, right? Then we have this thing called a shrink wrap agreement. A shrink wrap agreement is basically a like you open a box, and inside the box is a our terms, additional terms that you've not yet been made aware of. Generally, once you've opened the box, you've already completed the transaction. If you completed the transaction, you generally cannot add additional terms to the agreement. But then defining what the acceptance actually is a part of the trick of making a shrink-on agreement worked. So Ariel orders a new iMac from Big Dog Electronics, which ships it to her. Along, along with the iMac, the box contains an agreement setting forth the terms of the sale, including what remedies are available. The document also states that Ariel's retention of the iMac for longer than 30 days will be construed as acceptance of its terms. Right? So see how they set that up, right? Your choice, been given a choice, you bought the iMac, you can reject the terms by returning the iMac and receiving your money back within that 30-day period. In most instances, it's not even between the buyer and the seller, right? It is between the manufacturer and the end user, who may or may not be the buyer, right? So it does raise some interesting questions about voluntary consent, but they are relatively common to enforce these types of terms. Courts have had cases where they've enforced the terms of shrink wrap agreements in the same way as other contracts. The seller has to have, I'm sorry, the buyer has to have an opportunity to accept or reject, as in the iMac example, the terms after buying, right? But the courts will refuse to enforce these types of terms if there is no way for them to expressly consent, right? And here with the iMac example, right, keep it longer than 30 days, then you've accepted these terms. That sort of lingers on the border, but it's as close as a shrink wrap agreement can get. So some jurisdictions may not like them at all, and some will like them if they basically have some type of pseudo affirmative assent, as in the iMac example. The next category are browse wrap, and so browse wrap is sort of maybe a mixture between shrink wrap and click-ons. But like a click-on agreement, a browse wrap term occurs in a transaction that's conducted over the internet, right? But the browse wrap terms do not require the buyer or the user to assent to the terms before downloading or using certain software, right? The person can install the software without clicking I agree. In that case, if they're just sort of there, right, there's a good chance that a court is not going to enforce a browse wrap type agreement. So, click-on agreements, generally enforceable. Shrink wrap agreements, often enforceable. Browse wrap agreements create a problem because there's no way to even sort of conceptually create a fiction that there is a voluntary agreement in place. Again, these the laws that need to be considered here. The Electronic Signature in Global and National Commerce Act provides that no contract, record, or signature can be denied legal effect solely because it's in electronic form. There are some specific exceptions that require sort of, notarized or documents that require notarization, right? Or documents which need to be filed, like settlement agreements, sometimes are required to be, signed if they're going to be filed with the court. There may be other cases where there are some exceptions for public records, but other than that, now you can't deny the effect of an electronic signature just because assent was and signature means any indication, right? Because just as outside of the electronic context, any objective indication that the party was intending to be bound is sufficient to create a contract, right? And so an e-signature is an electronic sound, symbol, or process, not necessarily a handwritten signature or one that looks like a handwritten process, but any electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign the record. All right. So that's an important thing that needs to be considered. The Uniform Electronic Transactions Act also should be considered at this point. And so the Uniform Electronic Transactions Act, or UETA, is a uniform law, which means that it's a model law that's passed by jurisdictions individually, and its goal is not to change the basis upon which electronic records are given the effect of contract. That's accomplished under the Electronic Signatures in Global and National Commerce Act, or eSign. What UETA does is give a framework for the states, which sometimes have additional regulations for contracts that are applicable to that state, right? And it basically uses almost the same definition of electronic signature that's used in the Electronic Signatures in Global and National Commerce Act, and it also uses the same concept of simply not denying the effectiveness of a signature on a record simply because it is accomplished electronically. All right, so that's basically what it does. Uniform Electronic Transactions Act doesn't apply to all writings and signatures. It only covers electronic records and electronic signatures that are relating to a quote transaction. So Uniform Electronic Transactions Act. So it's not necessarily going to cover every type of contract. A transaction is defined as an interaction between two or more parties relating to business, commercial, or government activities specifically. It doesn't apply to wills, testamentary trusts, or transactions that are governed otherwise by the UCC other than Articles 2 and 2A, which you'll know if you take Business Law 2, those concern sales or leases of goods specifically. All right, so this brings us to the end of agreement. We will pick up with consideration shortly, but before you go there, please enter the prompt below.